Hello, I'm Brian from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover a very serious and often misunderstood topic in Korean criminal law. Can someone be charged with inflicting bodily injury by rape, even if rape didn't actually happen? The answer might surprise you. Let's start with the basics. Under Korean criminal law, rape is defined as sexual intercourse achieved through violence or intimidation that makes it difficult for the victim to resist. More specifically, the law defines rape as the insertion of the perpetrator's genitalia into the victim's. So, if there was no actual intercourse, does that mean there was no rape? In Korean law, an attempt means the perpetrator started committing the crime but didn't complete it, either because the act was interrupted or the intended result didn't happen. So in the case of rape, if a person uses violence or threats intending to commit rape but fails to complete the act, that's considered an attempt. And here's the critical part. Even if it's an attempted rape, if the victim is injured during the attempt, it can still lead to a charge of bodily injury by rape. This isn't just a legal theory. Korea's Supreme Court has also ruled on this. In a key decision, the court stated that even if the act was an attempt, if the victim suffered injuries as a result of the violence intended to lead to rape, then the charge of bodily injury by rape can still be established. In other words, you don't need completed intercourse for the law to apply. So, why does the law punish even attempted cases so seriously? There are a few reasons. Number one, the criminal intent has already been clearly expressed through actions. Number two, there's a real risk of harm to the victim. And number three, whether the crime was completed or not, the intent and the trauma inflicted can be equally serious. Some might wonder, what if there's no physical evidence like DNA? What if there was no insertion at all? Even in those situations, the court can consider the circumstances before and after the incident. If there is clear evidence of violence or coercion, and if the victim suffered injuries during the attempt, then the crime can still be prosecuted. So, what's the takeaway here? In Korean law, you don't have to complete the act of rape. In Korean law, you don't have to complete the act of rape to face extremely serious legal consequences. Attempting rape and causing injury in the process is enough to be charged with bodily injury by rape, which carries some of the harshest penalties in Korean criminal law. Well, we hope this video was useful for you. If you have any questions or concerns about Korean criminal law or attempted crimes, let us know in the comment section below, and you can find more information on seullawgroup.com. Don't forget to like, subscribe to our channel, and turn on the notification bell for more Korean law videos. And we hope to see you next time. Goodbye.